texts and Snapchat messages between Sills and the woman who knew each other from high school. Sills' lawyers want to keep the messages out of his trial, saying they haven't been properly preserved, disclosed, authenticated, and turned over to the defense. The trial judge may let them in if prosecutors can convince him of their admissibility. Sills is out on $25,000 bond. His lawyers say he is awaiting his day in court and the chance to return to the field after proving his innocence.
Earlier today, a detective began his testimony as the state's last witness. Audio and video of his testimony was not allowed. That's something the witnesses get to decide, and he declined being recorded or shown on TV. But we want to update you because during cross-examination of that witness, the defense tried to poke holes in the accuser's story. The detective was asked if Sills would have been able to lie flat on top of her, as she claims. The detective said no. The bench seat was 6 feet long. Sills is 6 feet 6 inches long, according to his NFL statistics. The detective agreed that her claim is questionable if she did in fact say that she laid flat. Now, the detective was also asked about prosecutors not going to the grand jury until 1 month before this year's Super Bowl. He agreed with the defense the case could have been brought earlier, though the judge explained to the jury that the grand jury meets about once a month, and during COVID, it was even less than that. All right, let's welcome our guest for this hour. Again, cross-examination is going on, but this witness has said no thank you to the media coverage. So we are going to bring in criminal defense attorney, former prosecutor Marie Pereira, and law enforcement litigation expert Sunny Slaughter. Girl power hour, ladies. Let's jump in because there's so much to talk about in this case, and it's really fitting, I think, for the three of us as females to talk about the fact that at the end of the day, when a prosecution brings a case like this, it boils down to he said, she said. Deciding for this jury, was there consent by the victim, as the defendant claims, or rather, was it rape by the defendant? And I worry, wonder, question how easy it is for there to be reasonable doubt, for this to be a really difficult decision for this jury. Sunny, your thoughts first.
I am thinking, based on what we know, that there is going to be some reasonable doubt in this particular case, based on the size, the gravity of her injuries, what the behavior was, and did she actually say no? I think that's what happens in a lot of cases. Did the individual say no? Did the person, the alleged perpetrator, hear the no? What was their actions? So I think, unfortunately, if this did happen, I believe that the jury's going to question more things than they're not going to question.
All right, what do you think, Marie? Because we know he's been charged with both rape and kidnapping. Your assessment so far of the state's case?
I think the state has a weak case, and I think I agree with Sunny. It is going to boil down to a he say, she say. Therefore, the jurors are going to use common sense evidence. And that's why on cross, his attorneys really focused on size. In this situation, size does matter, meaning the size of that vehicle and the size of the defendant. That's what I kept thinking about from yesterday. How in a tiny little red car with that big defendant was he able to try to rape her, get on top of her, and try to pry her legs open to the extent where she sustained injuries? For me, when it's a he say, she say situation, I look for outside type evidence that could show who is telling the truth. And it may be a tiny detail, but the size of that truck and the size of the defendant matters. And that's why on cross they focused on it. And I think it may just come down to that. Could all of that have happened the way she said it in that tiny little car?
And
Is
that reasonable doubt or not? I have no doubt the jury's going to talk about that point and really think about, well, but if someone even at 6'6" wants to fit in the backseat of a pickup or in a position that her story fits, is it possible? Is it plausible? Is it reasonable? And we have a big pickup truck and my husband's 6'6", so I do feel like they're going to think about their real common sense experiences to both of your points for them to make a decision in this case. Let's listen, though, because there was some really emotional testimony presented by the state to try to prove this beyond a reasonable doubt. And it was...
She tried hard to fight back. And she said that he tried to unzip her pants and physically sexually assault her the other way vaginally, but she got away. She said she had some strength that came over top of her, and she got out of the truck. And then she showed me the marks from where his hands was holding her down on her legs, on her inner thighs.
So really that testimony was emotional. She was upset on the stand, but it wasn't only this is what the victim told me, but also these are marks that the victim showed me where she said she was being held down by the defendant. Sonny, one of the other legal points of this particular testimony is why the jury was able to hear what the victim told her versus hearing that directly from the victim. Talk a little bit about that piece of it, and does that create any reasonable doubt in your opinion?
In my opinion, I believe that it might create some reasonable doubt because juries like to hear directly from the victims themselves. And this particular witness was very emotional, but the juries want to know exactly from the victim's mouth what happened. How did the victim feel? Not from what somebody else felt from it, because you could clearly hear that this witness felt the emotion from the victim, but they want to hear and feel what the victim may have been feeling at the time and why the victim did not testify. I mean, victims of sexual assault often don't want to testify, but this case is very it's very difficult when you don't hear directly from a victim.
All right, what do you think, Marie, as we listen to her friend tell the account of what the victim says happened to her?
I think the account was very impactful, and her breaking down into tears made her even more credible. However, I think on cross-examination, they really brought out the fact that she really didn't know this girl as well as she thought she did. And they tried to attack the victim's moral character by insinuating that she was a backstabbing, girl code breaking friend who was really interested in him and trying to date him after he dated her stepsister, and that this friend who's testifying as the outcry witness did not know this. So if you didn't know that, how well did you know this girl, and who are you to come to be her voice? I think they did a good job at just attacking the integrity of the victim and the true knowledge of the testifier on the stand.
They also brought out that this witness went to where she thought that the victim was home. She went to the home. The truck was there at the house. She looked in the windows. The truck was dark. She didn't see any lights on. She didn't hear or see any sign of a struggle or a problem. And so they also did an effective job, I think, bringing that out, that she was there physically, but certainly wasn't alerted that anything bad was going on inside that truck. One other thing I want to talk with both of you about in this case is the defense's case, because we know right now there's a detective on the stand. He's going through cross-examination. We anticipate, based on what the state told the judge, this is the last witness for the state. Then the state will rest. Do you think another one of these cases will Joshua Sills testify? Sonny, you first.
I think he will testify. I think he will tell his truth, whatever that is, and I think it will be to his benefit to tell the jury exactly what happened and to say it. If he does the opposite of what the victim is doing and speaking his own words and saying, look, I don't know what she's talking about because it was consensual, I think the jury, it will resonate in a way that people might not realize. They want to hear from him what actually happened.
All right, what do you think, Marie?
I agree with Sonny 100%. He is going to testify because he has to tell his point of view to explain that there was consent and how there was no ambiguity there. She said yes, she agreed to all the sexual acts that allegedly took place in that vehicle, and he did nothing to her that was against her will. He has to do that.
I think you're right. I too think that we may actually hear from him in this case. The defense said they did have witnesses to call. We don't yet know who all of the witnesses are going to be. So a perfect opportunity to squeeze in our necessary break. But when we come back, stay tuned. Continuing coverage. Lots of things, including Donald Trump stepping out of his airplane. Stay tuned. We'll be right back.
These are everyday people caught up in a plan to commit murder. But just who is the puppet? And who's pulling the strings?
Accomplice to Murder with Fanny Politan. Tonight, 7/6 Central. Only on Court TV.
Tonight on Closing Arguments, tracking the trail of the alleged Gilgo Beach serial killer from his commute to his career and how it all helped authorities make an arrest.
Closing Arguments.